Hi, my name is Corey Lancaster, Community Education Specialist at Legal Aid of Arkansas, and today I'm going to talk about the Fair Housing Act's disability protections and reasonable accommodations and modifications. Disability, or handicap, as it is stated in the Fair Housing Act, means physical or mental impairment which substantially limits one or more of a person's major life activities, or it can be a record of having such an impairment, or being regarded as having such an impairment. Major life activities can include caring for oneself, performing manual tasks, seeing, hearing, eating, sleeping, walking, standing, speaking, breathing, reading, communicating, and working, though this list is not exhaustive. It's important to note that disability does not include current illegal use of or addiction to a controlled substance. Broadly speaking, the Fair Housing Act bars housing providers from treating people with a physical or mental disability unfavorably because of that disability. This also means that a provider is liable if they fail to properly design and construct a dwelling in a manner consistent with the Americans with Disabilities Act or the Fair Housing Act design standards, which would allow a person with a physical disability to enjoy the full use and benefit of the property. The Fair Housing Act protects against a housing provider's refusal to rent, sell, or otherwise make unavailable dwellings because of an individual's disability. This could be a refusal to sell or rent a dwelling because of the person's disability, a refusal to negotiate the price of a dwelling because of the individual's disability, or even the provider's office not being accessible for people who are mobility impaired. The Fair Housing Act also prohibits housing providers' use of different terms, conditions, or services for those with disabilities. This could include refusing to accept a co-mortgager on a note because the purchaser has HIV, even though a co-mortgager would be perfectly acceptable to those without such a disability. This also includes denying access to common areas, such as swimming pools, to people with mobility impairment. The Fair Housing Act also requires that a provider allow for reasonable accommodations. But what is a reasonable accommodation? It is a change in a rule, policy, practice, or service that may be necessary to allow a person with a disability the equal opportunity to use and enjoy their home. If a qualified person with a disability makes a necessary and reasonable request, the provider must grant the accommodation. So how does someone make the request? The process begins when the housing provider is told of the disability and the need of something to change to accommodate the disability. The request can be either oral or written, but making the request in writing is usually best. If the disability is not apparent, the landlord may ask for verification of the disability, and there must be a relationship or nexus between the disability and the requested accommodation. And of course, the request must be reasonable. There is no time specified for when the request can be made. It can be made when applying, during the tenancy, or even to avoid an eviction. Once the reasonable request is made, a landlord must provide the requested accommodation unless they can show that doing so will impose an undue burden financially or result in a fundamental alteration in the services the landlord provides. A reasonable modification is a physical change in the existing dwelling that allows a person with a disability to fully use or enjoy their home. The provider must permit modifications, though they can be completed at the expense of the person with a disability. However, if the housing is federally funded, it is the owner's responsibility to pay for the modifications, though this does not apply to private landlords solely because they accept housing choice vouchers. Landlords may require the tenant to return the dwelling to its original condition, but only if the modifications will interfere with the next tenant's use and enjoyment of the premises. Landlords also can condition their permission for the modifications based on proper work, require necessary permits, require the tenant to set aside a reasonable amount of money over a reasonable amount of time, and an interest-bearing escrow account to pay for restoration, and require professional workmanship. One of the biggest areas of confusion many landlords and tenants have when it comes to reasonable accommodations is that of assistance animals. Typically, a service animal is an animal, usually a dog, that has been individually trained to perform tasks for the benefit of a person with a disability. An emotional support animal, however, is any animal that alleviates one or more identified symptoms or effects of a person's disability. An emotional support animal does not have to be individually trained or certified. For the purposes of the Fair Housing Act, service animals and emotional support animals are treated the same way and are referred to as assistance animals. They are considered tools, not pets, because they provide assistance or perform tasks for the benefit of the person with a disability. For animals, the housing provider must consider 1. If the person has a disability, and 2. If the person has a disability-related need for the animal. If the answer is no to either question, the accommodation request may be denied. If the answer is yes to both, the animal must be allowed in all areas where persons are normally allowed. The landlord can also deny the accommodation if the specific animal poses a direct threat to the health or safety of others, or if the specific animal would cause substantial physical damage to the property. However, this threat cannot be a mere speculation, and it must be an individual assessment of the specific animal in question. If the disability is not readily apparent or known to the housing provider, they may ask the person with a disability to submit reliable documentation from a medical provider or other professional of the disability and the disability-related need. If the disability is apparent or known, but the disability-related need is not, the provider may only ask for documentation of the disability-related need. The request must have an individualized assessment, may not be unreasonably denied, may not be conditioned on payment of fees or deposit or other terms and conditions applied to applicants or residents without disabilities, and the response may not be unreasonably delayed.
If you believe you have been a victim of a violation of the Fair Housing Act, call the Legal Aid of Arkansas helpline at 1-800-952-9243.